Welcome to How It Works, a video series from law sites in LawNext in which you get to see hands-on demonstrations of legal tech products directly from their developers. Today's episode, we're going to get a first look at a product that was just released called SimpleAI. It's an advanced AI-driven playbook builder designed specifically for in-house legal teams to accelerate contract negotiations and to mitigate risk. My guest today to tell us all about it and show us how it works is Preston Clark, the CEO of SimpleDocs, the company that developed SimpleAI. Preston, welcome to the show.
Hey, Bob. Thanks for having me. Great to see you.
Well, before we get into a demo here, why don't you tell us a little bit about your company and tell us about what you've just released here?
Sure. SimpleDocs is the company. We are a contract lifecycle management platform. We launched last year. Our first flagship product was Auto NDA. We very much take an unbundled approach to contract lifecycle management, and we find moments in time and use cases that we can solve for our customers and release those and enable our customers to use them. Auto NDA was wildly successful. Customers all over the world now using it every day, which is wonderful. And as the AI boom arrives and we see this opportunity to help the same in-house teams that are already our customers or our prospects manage third-party contracts in a more efficient way, these routine agreements, these NDAs, cloud service agreements, things that are filling up their inbox and taking lots of time, and none of us went to law school to review, certainly not myself. We want to streamline and accelerate that. So that's what we're announcing today. It's called SimpleAI. I'm going to show you a front-end experience of what it looks like as an attorney, redlining and interfacing with the document, as well as the back end, because we make it extremely easy for our customers to build playbooks on their own. So that's what I'm going to show you, and we're really excited to be announcing it today.
Great. Well, a picture is worth 1,000 words, so let's dive in and take a look at how it works.
Okay, let's do it. Okay, Bob. So as I mentioned, we're going to start with the front-end experience. We have a partnership with our sister organization, Law Insider, which I also co-founded, which is the creator of the standards movement of one NDA and one SaaS and one DPA. One SaaS is actually launching today. So by the time your audience is watching this video, right up here, there'll be a one SaaS playbook as well. But we come preloaded with a growing library of pre-existing playbooks, expert developed playbooks. We assume the majority of our customers are going to have their own custom, but to the extent that there's a gap, we'll be able to fill it. On the left, for purposes of the demonstration today, I have the mutual non-disclosure agreement. On the right, I have my one NDA playbook set up. I will, in a couple of moments, Bob, show you what it looks like to run a custom playbook and how to build one. But for illustration purposes now, I'm going to run the one NDA playbook. By itself is also configurable. So you can go into one NDA, make modifications to something like governing law or confidentiality period. You can input your fallback. So within our pre-built playbook, there's also the ability to configure. But for expedience today, I'm going to go ahead and run one NDA. Let's see how it goes. Let me go ahead and start the review. Of course, I've ran this already today, so I'm going to regenerate, start from scratch on the clean document. So here we go. We see the compliance bar on top, Bob. This is indicative of all of the issues that my playbook is designed to check for. And so in this case, there's 19 in total: non-solicitation, assignment, injunctive relief, residuals, term. And as this goes through, what you're going to see is a resolution rate. Right here, it says that 43% of this agreement is in compliance, or 48% is where it ended up, and 52% are at issue. So we're going to go ahead and resolve now the 52%. Right out of the gate, I see that there's an issue with term. I can go find where that presents itself in the document. In this case, it looks like it's suggesting a 6-year term that exceeds our internal policy. Our internal policy is to fall back to 18 months. And so I'm going to go ahead and apply that. And of course, the red lines take hold. We also can customize this to input comments. So you could add a comment. As a matter of internal policy, we don't accept any confidentiality period beyond 18 months, whatever it may be. So these things can be very, very configured for how you are used to interfacing with the review and negotiation process. Bob, side note, I want to keep us moving here. My single favorite part about SimpleAI, and I've been building and selling software for 15 years. My single favorite part is that our customers understand it implicitly and immediately. Oftentimes in selling big contract lifecycle management or big HRIS systems, whatever software you're selling, the buyer only really tangibly understands 5 or 10% of it because so much of it is going to get pushed out to the rest of the organization. But with a tool like this, even if you're a senior attorney that is pushing down the work into your organization, from time to time, you're still negotiating an NDA or reviewing a cloud service agreement. You now test a tool like SimpleAI, and you'll know within a minute and a half how it compares to what you would do. Does it negotiate in a similar way? Is it catching the same flags or issues that I myself catch? And so I love this. And so I encourage everyone to test this out. Give it a try. Even if you have another competing tool, try it, because I think you will instinctually get its usability and its viability as a replacement to sort of the legacy way we've reviewed agreements in the past. So I'm going to go ahead.
Can I just ask real quick? I assume the redlines are customizable as well. I mean, if I had wanted something, if I didn't want 6 months or 18 months, if I wanted to put something else in there, could I have done that?
Yeah, exactly. So if I go all the way back, which I'll do in a second, some of that is configurable at the standards level. So I can go in and modify the one NDA standard to the default 18 months, but will accept anything from 12 to 24. So in this case, if it had reflected 24 months or 2 years, it would have automatically accepted it because it's within our fallback range. If it goes to 6 years, as this one did, and it's clearly outside that range, then it would fall back to whatever your default is, Bob. In our case, it's 18 months. It could have been something else. I'll apply a couple more of these. I want to get to sort of the end point so you can see what it looks like when it's done. But all of these are modifiable. There may be an issue that is detected. You can always rerun the AI against individual clauses until you get a satisfactory result. Okay, now it says all set. We're at 100% compliance. There are two types of issue spotting that the tool enables. One is a red line, and these are very binary. We don't accept non-solicitation, or the term length exceeds our policy, so it needs to be modified. But in other cases, it may be something like the definition of confidentiality is too broad or not broad enough, in which case these can be flags that indicate you ought to review it and decide whether or not, based on this relationship or the circumstances of the deal, whether or not to accept it or to modify it yourself. So we have the ability to not just redline, but also flag potential issues that the lawyers can use to discern and decide at their own discretion what to do. So that's it. I'm done now. If there are comments preloaded, those will appear along the side as well. But we've now run through a standard playbook. So I do want to pause there, Bob, because I want to show you how we can now go and create a playbook ourselves. But before I do that, the chat feature, if you don't have a playbook or you just otherwise want to be able to interface with the document in a specific way, maybe you've just received a 10-page NDA and you can't imagine what's possibly inside a 10-page NDA that isn't things that shouldn't be there, you can interface with this document. And so I'll just type in, please summarize any risks within this agreement. And let's see what it produces. It's going to analyze it, identify any clauses that are non-standard. And again, this is a catch-all. This is a mechanism to go outside the scope of the playbook, and certainly a way to interface with documents for which you don't have a playbook. So in this case, it's saying maybe there's unauthorized disclosure issue, the duration, there's no warranty, indemnity. So it's identifying issues that may have been picked up in the playbook or maybe not.
What's the basis on which it's identifying those issues? How does it know what an issue might be?
The model as it exists right now is just, we're using OpenAI. We're looking at other LLM models that are emerging out of China and elsewhere to see what is best practice. But this is a way, just from a best practices perspective, we will very soon be layering in a deeper integration with Law Insider, where we'll also be able to do a what's market analysis based on a larger data set, a proprietary data set that goes beyond the capabilities of OpenAI. So the chat feature, of course, can also generate clauses that can be moved over, generate the language or gaps you've identified. And then later this year, we'll also be launching clause libraries. So you can have your own set of clauses where the confidentiality definition is not what you need. You can literally pull in your own and move it over directly. So all of this is coming in the next couple of months. Bob, I do want to pause here and switch over to the Playbook Builder. That is the show of the day and sort of the thing that we're most proud of. And so I'm going to pause here and move over to that. Okay, so the front-end experience is what we just looked at, Bob, and obviously that is what your attorneys will be using on a daily basis to process third-party agreements, to accelerate the review times. But on the back end, every playbook is a set of prompts that are configured around your rules or guidelines for how you negotiate agreements. As I mentioned, SimpleDocs is a full contract lifecycle management platform. We launch point solutions like Auto NDA and now SimpleAI. All of these get rolled in on the back end. I'm looking now at my Playbooks tab. This is where you see one NDA, you see one SaaS will be here shortly. I also have the ability to create a custom playbook. So we were at the University of Miami recently meeting with students, working with them to develop their own playbooks, teaching them how to not build playbooks inside of a spreadsheet, but how to build it directly within the tool. And so one of the ones we came up with is non-solicitation. We do not accept non-solicitation clauses. If present, remove and add a comment that we don't accept non-solicitation as a matter of policy. So this, while it may seem very straightforward, is a very foreign concept to someone like me who went to law school and over time developed our own playbooks and spreadsheets, but didn't necessarily learn how to prompt. The beauty of this tool is that you can create prompts, you can give instructions, everything from what to identify to how to make changes to what comments to leave. And then, as I mentioned before, Bob, we have the ability to either create a suggestion or a red line. In the case of a suggestion, we consider this to be a flag where when I run the tool, mostly what it's going to do is just indicate whether or not this might be an issue for me to investigate further. Whereas a red line, very binary, it's going to say this falls outside the policy and therefore should be redlined as such. And so these are very easy to modify. And most importantly, they're very easy to test. Neither our implementation team nor the attorneys who use us expect to implement a custom playbook the first time perfectly. Again, as I mentioned a few minutes ago, there's this very tangible aspect of the product, which is you are going to run it and know immediately if it functions in a way that is consistent with how you negotiate. And you'll know the clauses that it got right and clauses that it got wrong. We have a dedicated customer success team. We will help you through that process. But ultimately, in its scale, we expect that whether it's through our tool or someone else's, that you as lawyers will become very good at not only creating your own prompts, but testing them. And that's the thing we're working with the University of Miami School of Law on, teaching students how to go through that cycle of let's implement some prompts, let's run it now live, let's push it live and see how it responds to a document. We've identified some issues, now let's modify it. And so an example of that may be that we've misworded something in our term length or our confidentiality period, or we sort of don't think about this in the right way, and we think only of our default confidentiality period is 2 years, and then someone inputs 18 months, and we say, oh gosh, no, we didn't mean not 18 months, we just meant 2 years as our default. So through this process, we can start to learn phrasing best practices, prompt best practices to develop a tool that mirrors how we want to negotiate and how we would have done this ourselves without a tool like SimpleAI. So I'll pause there, Bob, if you have any questions about it, but that is how the Playbook Builder works. And these, once I save changes, this is immediately pushed to the Word add-in.
The question I have there is that, what if I'm a contract attorney who's developed this perfect clause for this perfect situation? Can I just drop that language in there and make that part of the playbook?
Absolutely. This is probably not a great example here. So let me go back and find one that is like the definition of confidentiality being maybe not broad enough purpose. So let's say, for example, Bob, I wanted to say, check for the presence of purpose. If missing or unclear, this agreement is intended to facilitate blah, blah, blah. So this is the exact use case you just described where I identified a gap, or I could say it's not there, or as it's worded, it is not sufficiently broad. Now suggest this exact language. So you can both do that for comments and for direct red lines, but you don't have to do that. So in the case where it's something like a term length, you're not going to explicitly tell it how. We want AI to do some of the work for us. So we want the AI to not just rip and replace an entire clause. That's going to create more negotiation cycles. You're going to want it to identify the specific issue and redline it and only it rather than replace everything. But you're exactly right. There are circumstances where it is appropriate to literally replace or change with a different definition. And you can be hyper explicit with the AI, with the playbook builder in doing so, as is reflected here.
And I know you just released this to kind of general availability, but I also know that you've been testing this in beta for a while. Can you talk about anything you've learned or how you did the testing on this?
Oh man, yeah. So we've learned a lot. I mean, as anyone will tell you, you put something in beta, the best thing you can hope for is customer feedback and people actually using it, because, as I've mentioned, it is so connected to work you're already doing. You just, like, I wake up in the morning and go in Slack and there's, 20 pieces of feedback from, we have beta customers in the UK, in Qatar, certainly all over the US, and they are banging on this thing every single day. And what's perfect about this is it's providing enough value, and has since day one, that it was saving them time, but they wanted to make it better because there's still these last mile issues. And so, things like the chat feature. When we launched, there was no chat feature. We've made the customization of playbooks more intuitive and easier. Bob, when we launched, we weren't even going to make this builder available because we thought we didn't want to put this pressure on our customers. And we said, no, we're an enterprise sales organization. We have dedicated customer success managers. We are prompt experts. Let us do this. And they just ripped it out of our hands. And they said, no, like, I'm up at 2 a.m. This product is great. I want to be able to change it because I've identified a bug in how my prompt was built initially, and I want to get good at this. And so it's things like that, how we summarize just the intuitive nature of the compliance bar that I was showing you a couple of minutes ago on the top, so that people saw the progress, the full list of all of the issues, so that they know whether or not something has been identified or just somehow got ignored. So they're saying, oh, no, it checked for non-solicitation and it is marked as compliant. So just we get better every single day on this, and the number of users already on the platform, it's in the dozens now, allows us a feedback loop that post-launch, so today onward, is only going to accelerate.
Great. I'm sure there's a lot more you could show us about this. Is there anything else you wanted to point out today before we wrap up here?
Yeah, the only thing I would say is that this is integrated with Microsoft Word. It's SOC 2 compliant. You can go to the Microsoft App Store, download it. The Law Insider standard playbooks. So one SAS, one NDA, one DPA. You don't have to create an account. There's guest access. So you can download the Word add-in, go to guest, start playing with it. You don't have all of the capabilities I just shared. So you can't, preset your term length, or you can't create a custom playbook. You have to create an account for that. But you can use the off-the-shelf standard playbooks and see how it goes. So I encourage everyone to test it out. And if you want to learn more, you can go to SimpleDocs.com and request a demo.
And on those preloaded playbooks, more to come, right? You're going to be developing more of those over the next year.
A ton. Electric Epona and the team at Law Insider are threatening to put out 20 standards and standard playbooks this year. So our hope is by December 31st, we're going to have 20 plus loaded into the Word add-in.
Great. Well, it looks great. And I appreciate your coming on the show to tell us about it.
Thanks so much, Bob. Appreciate it.
That's it for How It Works for today. You can find the full backlog of these at directory.lawnext.com or on YouTube. Just search for How It Works there. This is Bob Ambrogi. Thanks for watching.